And in this instalment of the 2TG Property Damage webinar series, we will be discussing the wonderful world of the Party Walls, Etc. Act 1996. If I had to sum up the Party Walls Act in a single word, that word would be fiddly. The Act contains detailed and not always intuitive rules, which knit together to form a self-contained statutory regime entirely separate from the common law rules on land. A key feature of party walls cases is that they rarely end up in court because the statutory scheme was designed to avoid litigation as far as possible. So in the general run of things, these cases are unlikely to be crossing our desks on a particularly regular basis. Nevertheless, you can't keep lawyers out of the game entirely, and there are some areas on which we're more likely to be asked to advise than others. Those areas will, as far as possible, be our focus today. But the specific and the nuanced is not much use without an understanding of the general. And so we'll first spend a small amount of time looking at the context in which the Act operates and the requirements which must be met before it applies. So, taking that approach, we will first canter through the threshold requirements for the application of the Party Walls Act. Then we'll have a look at one specific right provided for in the Act, which forms the basis of many of the reported cases, namely the adjoining owner's right to compensation from the building owner for damage caused to their property. Third, we will take a look at what happens when things inevitably go wrong and how disputes relating to the Act are dealt with both within the context of the statutory scheme and also in the courts. And then finally, we'll consider a recent case heard in the High Court on the Act, the case of SHAH and Power. But first things first, why is there a Party Walls Act at all? Now, as we all know, English common law, as it relates to land, has very deep roots, and much of it developed before the advent of widespread urban living. For that reason, the common law rules have the potential to cause all sorts of problems when they run up against the realities of modern living. For example, let's take Anita and Bob. They live in adjoining semi-detached properties where the dividing wall straddles the legal boundary between the two parcels of land. And as we can see, Bob lives with his elderly mother, Beryl. Anita is carrying out some renovations to her own property, which require her to work on the party wall, that blue and green wall dividing the two properties. Now, under the common law, any work to the party wall without the consent of the other owner is trespass. So by carrying out renovations to her own house, Anita is leaving herself open to a civil claim for trespass or for nuisance. Similarly, under the common law, if Anita's work damages Bob's property, for example, it causes cracks to appear in the walls, then his only remedy is recourse to the courts, which, as we all know, can be expensive, time-consuming, and rather more acrimonious than you'd like when you live next door to the other party. It's in situations like this that the Party Walls Act was designed to resolve. As I've said, Parliament has created in the Act a self-contained system of rules which carve out an exception to the usual common law laws on land. Now, these rules permit landowners to carry out works that would otherwise be a trespass or a nuisance by providing them with a statutory defence to civil claims. But it also puts in place systems to ensure that the interests of nearby owners are protected and any disputes are dealt with as efficiently and swiftly as possible. So that's our context. The first question that we need to ask when faced with a new case which might have Party Walls Act issues is, unsurprisingly, whether the Party Walls Act in fact applies at all. Now, there are two elements to this question. The first is, could it apply? Are the facts of the case such that it prima facie falls within the scope of the Party Walls Act? And to do so, it must involve the right kind of people, the right kind of structure, and the right kind of work being carried out. Once we're satisfied on that score, the second question is whether the Act has been invoked correctly. And this is the stage that we start thinking of originating notices and consents. Now, we're not going to dwell on either element in too much detail today because they're both set out comprehensively in the Act itself. But I'll try to give you a flavour to orientate you in the Act if you're not familiar with it. So, first question first. Is this prima facie a statutory case? Step one is considering who is involved. Now, in most cases, the only people we are going to be concerned with under the Act are the building owners and the adjoining owners. And just as a health warning early on, the definition of owner, which is given in section 20 of the Act, stretches far beyond the concept of a freehold owner to include landlords and all tenants whose lease is longer than a year. So it isn't the most intuitive definition, and it's worth double checking. The building owner is defined as the owner who is desirous of exercising rights under the Act. In other words, the person who actually wants to carry out the work to begin with, in our example, Anita. The adjoining owner is naturally enough the other party, for us, Bob. Now, depending on the situation, the adjoining owner might be the next door neighbour, which is quite straightforward, but they might also be the neighbour in the upstairs flat, or if we're talking about excavations under the Act, the owner of a plot of land which is not immediately adjacent to the building owners. So that is another area where we just need to be careful. The only other category of person to mention is the adjoining occupier. In our example, Beryl. Beryl isn't an owner, she is a licensee in her son's house. She lives there but doesn't have a lease. Now, adjoining occupiers have a very limited role to play under the Act, but they do have a right to be compensated by the building owner in certain circumstances. So it's always worth keeping an eye out for non-owners, especially family members, who might also have a claim. After checking the right people are involved, we need to consider whether the work is being carried out on a relevant structure. Again, the definitions are set out in section 20, and should you purchase the new 2TG property damage book, there are handy diagrams in there. But it's worth noting a couple of things in passing. The first is that a party wall might be the classic example you're probably thinking of, which is a wall dividing two adjoining properties that lies on the legal boundary between them. But it also might not. In short, a wall will be a party wall where it's one, part of a building, and two, either straddles the legal boundary or separates buildings belonging to different owners. Now, this either-or definition means that you can have a party wall which is part of only one building with, for example, the adjoining owner's garden on the other side, or indeed a party wall that stands on the land of only one person, but nevertheless divides the land of the properties of two people. A party fence wall is what it sounds like. It's a wall which fences off one parcel of land from another, and that does have to straddle the legal boundary, unlike a party wall. And then finally, party structures bring horizontal divisions into play. And the classic example is the floor partitions between different flats in the same building. Although it's worth noting that there's a slight sting in the tail of this definition as well. In order for something to be a party structure, the two properties have to have different staircases or different entrances. So while a classic block of flats would likely fall within the Act, a house of multiple occupancy, for example, probably wouldn't. Finally, we get to the types of work that are within the scope of the Act. Now, the rules are in the sections set out on the slide. Section 1 for new buildings and structures, Section 2 for work to an existing wall or structure, and then Section 6. Now, Section 6 has the most complicated rules, and it gives us the etc. in the Party Walls, etc. Act. Section 6 relates to situations in which the building owner is excavating entirely on his own land, but so close to the adjoining owner's property and to such a depth that it poses risk to structures built on the adjoining owner's land. Under Section 6, the main trigger point is whether the building owner's excavations will go deeper than the foundations of a structure on the adjoining owner's land. If it won't, then you don't need to bother about the Act. But if they will go deeper, then it's a question of how much deeper the excavations will go and how close to the structure the excavations will get, because different rules can apply in different circumstances there. And I'm afraid at that point, there's nothing for it but to grab the architect's plans, a protractor and a large cup of tea, because they can get quite fiddly, as I've said before. The other component to Section 6 is the definition of a structure. Now, as far as I know, there is no authority directly on that point. But for my money, a common sense view would suggest that any built structure that is attached to the land in a reasonably permanent fashion would be a structure within Section 6, but something that lacks those characteristics would not be. So, for example, a swimming pool, or a summer house, or even maybe a substantial brick-built barbecue would probably be a structure under the Act, whereas a plastic garden locker, however big, probably wouldn't be. So once we've established that the facts of the case fall within the scope of the Act, what then? It's broadly accepted, and we will return to that point later, that unless an originating notice is served by the building owner, the Act has no applicability, even if the facts of the case fall within its potential scope. And by originating notice, that isn't a term that's found in the Act, but I use it as a catch-all term to cover all of the statutory notices which are supposed to be served before the work starts. So, in other words, it's generally accepted that the common law rules apply unless and until the building owner triggers the Act by going through the steps set out in the statute for availing themselves of its network of rights and protections. Now, each type of work under the Act has its own notice requirements set out in the relevant section, and inconveniently, they're all slightly different, which again makes it fiddly and means you are going to have to go back to the Act for the details. In broad terms, there are three things to consider when thinking about originating notices. First, what are the requirements for this type of work, both in terms of the notice period, but also the content of the notice that has to be served? Second, what responses are available to the adjoining owner? And third, if a notice is consented to by the adjoining owner, is that, or does the originating notice expire? So let's take an example. Curtis, our man in blue, wants to build a new party fence wall, which straddles the boundary between his garden and that of his neighbour Debbie. There's our wall. Now, this is work under Section 1 of the Act because it is an entirely new structure which is being constructed. Now, if Curtis wants the rights and protections of the Act, before he starts work, he has to give Debbie, the adjoining owner, written notice of his intentions, and that must be 1 month before the work starts, and it also must set out a description of what he intends to build. On receiving the notice, Debbie has two options under the Act. She can serve her own notice on Curtis, giving written consent to the works. Now, that has to be done within 14 days, and if it is, all hunky-dory, and there are no time restrictions on that work being carried out. But if Debbie doesn't give consent within 14 days, then it's deemed that her consent has been withheld. Now, in that situation, Curtis is allowed to build a wall, but it must be entirely on his own land and can't straddle the boundary, save that he is allowed to place footings under Debbie's land. Now, this permission is time restricted. So if he wants to use Debbie's land in this way, he must do so within 12 months of the originating notice, because if he doesn't, the notice expires and he has to go through the whole process again. A further example, let's assume that Ewan wishes to excavate close to Fiona's foundation. Now that's within section 6 because we are excavating close to a boundary. Under section 6, there is a similar regime of notices as to our previous example. However, there's an addition. Presumably because of the greater risk of damage to the adjoining owner's property where excavations are concerned, Ewan's originating notice must, as well as describing the intended works, include plans of how he proposes to protect Fiona's foundations. Similarly, there's additions in terms of what Fiona can do next as well. Instead of just giving or withholding her consent, Fiona has another option. She can consent on the condition that further or different measures are implemented to safeguard her property than those specified in Ewan's original notice. Now, if Ewan agrees, again, that's all fine and the works can progress. But if he doesn't, a dispute is deemed to have arisen, and that will then be determined under the mechanism that we'll come on to shortly. So that was a whistle-stop tour of what we could call the threshold requirements of the Party Walls Act. But once a case is safely within the scope of the Act, we need to consider the rights and the obligations that it creates. As with notices and consents, this is pretty comprehensively laid out in the statute, so I'm not going to go through each provision of the Act in turn. Instead, we're going to take a look at the statutory right that perhaps causes most disputes of all, the right to compensation. From the building owner's perspective, the Party Walls Act 1996 seems like a pretty good deal. Once they've served an originating notice, and that isn't particularly difficult generally, and they've received either the adjoining owner's consent or a surveyor's award authorising them to proceed, the building owner has a defence to any civil law claims that the adjoining owner would otherwise be able to bring in respect of the works, so trespass or nuisance being the prime examples. In addition, the building owner has rights of entry. So even if the adjoining owner is being difficult and doesn't want to let them onto their land, they can be compelled to do so, including by way of criminal sanction. So the Party Walls Act is quite a powerful tool once you've brought yourself within its scope. But on the other side of the scales is the adjoining owner's right to compensation. Now, there are provisions relating to compensation and the making good of damage in each of the sections that enables the different types of work the Act covers, so section 1, section 2, and section 6. But in addition, there is a freestanding provision in section 7.2, and that's what generally comes to the fore. That reads, the building owner shall compensate any adjoining owner and any adjoining occupier for any loss and damage which may result to them by reason of any work executed in pursuance of this Act. So as drafted, section 7.2 gives rise to an extremely wide-ranging right to compensation. Unsurprisingly, this has been pending or given shape by the courts over the years to bring it in line with the damages awarded for common law torts to land. Given this, there are certain heads of loss which are quite clearly recoverable, subject, of course, to the usual rules on proof. For example, it's unlikely to be contentious that if a building owner breaks a window while erecting scaffolding, they're going to have to compensate the adjoining owner for that damage. Similarly, if the work is so disruptive that the adjoining owner can't reasonably be expected to live next door, then the costs of alternative accommodation during the works is also likely to be recoverable. However, if the adjoining owner, or the adjoining occupier for that matter, can satisfy the common law principles of causation, remoteness, and mitigation, then there's no theoretical limit to the losses that they can claim for. For example, assume Kevin, the adjoining owner, has a very successful hypnotherapy practice, which he runs from a room in his home. His neighbour John knows all about this because Kevin has repeatedly told him that he doesn't mind the works being carried out as long as the builders don't cause noise between 2 and 4 p.m. on Tuesdays and Thursdays. This, he says, is because he sees a long-standing and very wealthy client during those times, and the sessions can't take place unless there's peace and quiet. Now, if John ignores Kevin's request and causes noise, and Kevin tries to find an alternative venue for his practice, but he can't, then what if his cash cow of a client decides he's had enough of having his therapy disrupted and is going to go and find another therapist? Kevin then has lost a significant source of income. Now, on these facts, I would argue that Kevin has suffered a clear and foreseeable loss of his income as a direct result of John's works under the Party Walls Act. And that's despite his best attempts at mitigating his loss by trying to find an alternative venue. Now, in such a circumstance, I can't see any reason of principle why Kevin couldn't recover that loss of income, although it's not something, to my knowledge, that has ever been tested in a court. Once entitlement to compensation is clear, the amount of compensation falls to be determined, and that will also be determined by the surveyor appointed as part of the statutory dispute resolution process, which will come on to very shortly. Now, if payment of those sums isn't forthcoming, then the adjoining owner can pursue the building owner in the courts for civil debt, as confirmed by Section 17 of the Party Walls Act. So again, that might be a situation in which we are asked to get involved. Before moving on, it's worth noting that payments under the Act don't go all one way. As a general rule, the building owner is responsible for paying for the works they undertake, which makes sense because they're the ones that want to carry out the work in the first place. But in certain specific circumstances, which are all set out in Section 11, the adjoining owner is expected to contribute. Now, the most obvious one of these is where the adjoining owner requests that additional work is carried out at the same time as the building owner's works. But they may also be asked to contribute where they haven't asked for anything to be done. For example, if the works are only necessary because the party wall is in such a state of disrepair, and the adjoining owner is partially or even entirely responsible for it getting into that state, then they will be obligated to pay a proportion and potentially the whole of the costs of sorting it out. So it's not a case of rights one way and payments the other. There can be a complex network of payments and accounting between the parties. So on to the lawyer's favourite topic: what happens when things go wrong? Now, when a dispute arises within the Party Walls Act regime, whether that's a refusal by the adjoining owner to provide consent for the works, or a disagreement about their scope, or about the cost of making good damage, then that dispute will be resolved by a surveyor or surveyors, following the procedure set out in Section 10 of the Act. Now, it's worth noting right at the outset here that the word surveyor is not a technical term, like the phrase chartered surveyor. Under the Act, there are no particular requirements for a surveyor. It seems that pretty much anyone can be appointed by the parties to be their party wall surveyor, even if in the rest of their life they don't do anything that looks like surveying. Now, in an ideal world, the parties are on good enough terms to appoint a single surveyor on a joint basis. That's always the default position. But unsurprisingly, that isn't always the case. Now, if the parties can't agree on a single surveyor, then each party appoints their own, who between themselves agree on the appointment of a third surveyor. That third surveyor can then act as the casting vote should the two party surveyors disagree. But even the three-surveyor system requires some cooperation from the parties and indeed their surveyors, and they don't always play ball either. So the Act does make provision for situations where one party or their surveyor point blank refuses to engage with the system. They are quite detailed, they're all in Section 10. Once a surveyor's award is made, then it is conclusive, save for a very limited appeal to the county court. As this is conceivably the first time a lawyer might have been called into the case, there are a couple of points which should be highlighted. The first is that the time limit for appeals to the county court is brutally short. The disappointed party has only 14 days from the service of the award to make the appeal, and that's not a time limit that can be extended by the parties. Second, when calculating that time limit, because the award is not a court document, we are not using the usual rules on service as set out in the civil procedure rules, which means that we need to be calculating our 14 days using definitions in the Interpretation Act 2007 instead, and that can also lead to getting a bit snarled up in the detail, so be aware of that. So far, so good. If either party disagrees with a validly made award, they can appeal. But what happens if it isn't clear that the award is valid? It isn't clear that a surveyor has been appointed correctly. Now, that's likely to arise in two circumstances. First, where there is a question over whether a valid originating notice was ever served by the building owner. In other words, whether the Act is engaged at all. And second, issues of validity might also arise where it's clear that the Act is engaged, but the question is whether the surveyor has been properly appointed. For example, they might not have been appointed in writing as required by the Act, or they might have been appointed by the wrong person. Now, in the first of these instances, it's reasonably clear to me, although there is no direct authority either way, so scope for argument, that the surveyor can determine the validity of an originating notice. At the end of the day, the surveyor's job is determining whether or not a building owner should be permitted to carry out the works that they propose. Now, the validity of the originating notice is fundamental to that, because without a valid notice, then the building owner has no statutory right to impinge on the adjoining owner at all. So it seems to follow that the surveyor, in order to carry out their tasks, has to be able to consider whether an originating notice is valid or not. To my mind, the more interesting point is the second, whether a surveyor can determine whether their own appointment is valid or whether that would require a declaration by the court. Now, this turns on the proper understanding of the surveyor's role, because if a surveyor is properly characterised as an arbitrator, then they do have the power to determine the validity of their own appointment. However, it seems on balance that this isn't the case. Under the Party Walls Act predecessor, it was held that a surveyor's award is better characterised as an expert determination, not as an arbitral award. Now, that's not binding authority under this Act, but there's no differences in wording between the statutes to suggest that the court would be likely to come to a wildly different conclusion if the same question were to be asked today. So if there is ever a question about the validity of a surveyor's appointment, and after the appeal time has expired, that's going to be your best way of attacking an award, the appropriate response is to apply to the court for a declaration on the issue. And it's important that this is done promptly, because any delay, which allows the surveyor to continue to act despite questions over their validity, has the potential to give rise to an estoppel. So another area in which promptitude is key. Now, as we've just seen, the Party Walls Act provides a comprehensive dispute resolution scheme for cases which fall within its purview. But that doesn't mean that cases involving party walls never bother the courts. The first typical scenario where cases will end up in the civil justice system is where the building owner hasn't followed the notice procedure set out in the statute. If we're in a situation where work has been carried out, but an originating notice has never been served at any stage, there the building owner is in difficulty. As we've seen, for them to benefit from the statutory defence to common law actions, they must have served a valid originating notice, and then either have obtained the adjoining owner's consent or a surveyor's award authorising the works. Now, if any of those elements are missing, the adjoining owner can bring a common law claim in trespass or nuisance, and the building owner will have no statutory defence. But what about the situation where the missing element, the valid originating notice, is provided, but it's provided after the works have started, but before a claim is instituted? For example, let's assume that works to a party wall started in April without the adjoining owner knowing anything about them. Then in June, the building owner serves an originating notice and the adjoining owner consents to the works. So from June onwards, any damage caused is going to be subject to the statutory dispute resolution regime and not the courts. But if it becomes apparent that between the work starting in April and the consents and notices in June, damage was caused in that intervening period, can the adjoining owner bring a civil law claim in respect of that damage? Now, the traditional view on this question is exemplified by the case of Louis and Sadiq. Now, this case was decided by the Court of Appeal, but under the London Buildings Act Amendments Act 1939. Now, that's one of the predecessor statutes to our Party Walls Act. Because of that, it's not binding authority anymore, but the provisions are very similar, as is often the case with these statutes. And so earlier authorities are usually treated as very persuasive. Now, in Louis, the building owner invoked statutory procedures after the work started and after it is alleged that damage was caused. When the adjoining owner brought a claim in respect of that damage, the building owner argued that the common law regime was entirely excluded by operation of the Act. In other words, that his notice, which was served after the works had started, could operate retrospectively to provide him with a defence. Now, this argument was rejected. Lord Justice Evans said, if the building owner commits an actionable nuisance without giving notice and without obtaining consent, he cannot rely upon a statutory defence under procedures with which ex hypothesi he has failed to comply. If he does give notice, he will, in due course, acquire statutory authority for whatever works are approved or agreed. But in my judgment, this does not relieve him from liability for the continuing nuisance which he has unlawfully committed until such a time and to the extent that such authority is obtained. In other words, according to Lewis, an originating notice cannot have retrospective effect to provide a defence to a cause of action which was perfected before the notice was made. Now, to me, this makes a lot of sense. However, it has been brought into question by the more recent case of Rodriguez and SHAH. The factual situation in Rodriguez was very similar to Lewis. Sometime after the relevant works had started, the building owner served an originating notice and then used the statutory dispute resolution procedure to obtain a surveyor's award, which found, as a matter of fact, that the works had not caused any damage at all to the adjoining owner's property. Unsurprisingly, the adjoining owner disagreed with this award and attempted to bring common law proceedings in respect of the alleged damage. As a preliminary issue before trial, the court was asked to determine whether the adjoining owner was entitled to bring the proceedings at all, or whether they were precluded by the award of the surveyor. In Rodriguez, the court found against the adjoining owner on the basis that the surveyor's award determined the issue conclusively, even though the Act's provisions weren't invoked until after the alleged damage had started. Now, as far as it goes, Rodriguez takes precedence over Louis because it concerns the modern Act. However, for my money, Rodriguez needs to be understood in quite a limited way. Now, what we often see is Rodriguez being used to argue that once the statutory scheme is invoked by way of originating notice, however late in the day that might occur, the adjoining owner can no longer rely on the common law at all. But in my view, that's erroneous, because it amounts to saying that a surveyor, an individual with no judicial authority, can act to remove a pre-existing and complete common law cause of action. Now, I don't think that the statutory language is clear enough to bear that, I think, very strange state of affairs, and I don't think that Rodriguez mandates it. Instead, for my money, the key to understanding Rodriguez is the distinction between a cause of action and the underlying facts on which it is based. Now, in Rodriguez, the surveyor's award included the factual finding that no damage was caused to the adjoining owner's property at any stage, either before or after the act was invoked. As a result of this, if the adjoining owner was to succeed on their claim for property damage, the court would need to make findings of fact which directly contradicted those in the surveyor's award. However, on my reading, there is nothing in Rodriguez to suggest that if the adjoining owner was to bring a claim that wasn't based on factual findings which were contradicted by the surveyor's award, for example, if the surveyor had confined themselves to considering the north part of a house and the civil claim was only in respect of the south part, that this would also be precluded. So while Rodriguez is an interesting authority, I would caution against interpreting it more widely than it needs to be interpreted. Another area of contention regarding the relationship between the Act and the courts is whether an aggrieved adjoining owner who feels that their neighbour has failed to follow the statutory procedures can claim for breach of statutory duty. Unfortunately, a clear picture doesn't emerge from the authorities, and the people that have strong opinions about the Party Walls Act, like me, are divided on this issue. So it's certainly one to keep an eye on and to check back into if it ever comes up in one of your cases. But on the authorities as they stand, for my part, I don't believe that the Party Walls Act can found a claim for breach of statutory duty. In the first instance, as a matter of principle, there is no evidence that Parliament intended for the duties within the Act to be actionable by private individuals. In addition, it's far from clear to me that a cause of action in breach of statutory duty is necessary, that it will be plugging a gap in the law. Because where the Act is engaged, the parties have access to the system of surveyors with a right of appeal to the civil courts, as we've seen. And where the Act isn't engaged, then the common law applies, along with all of the remedies that would usually follow. So from a matter of principle, I don't think a breach of statutory duty claim would add anything. Considering the authorities, well, we run into the same problem that we often do in this area. There aren't a great deal of them. The majority of reported cases on this topic were heard by the county court, so not a binding authority anyway, where generally claims for breach of statutory duty have not met with a great deal of success. Now, that would be straightforward enough, but complicating the picture is the case of Crowley and Rushmore Borough Council. In that case, His Honour Judge Thornton QC found that, and I'm quoting, any failure to serve the requisite notice before work started would amount to a breach of statutory duty, which would allow a court to award damages representing the compensation which would have been awarded by the surveyors appointed under the Party Wall Act. Now, as a matter of precedence, as a High Court judgment, Crowley does give authority for the claim that a breach of statutory duty, is available in certain circumstances. Crowley hasn't been overturned, so if you want to make that argument, that's probably your best bet. But if that isn't convenient for you, here are a couple of points which might help you get around it. The first is that Crowley was only concerned with a claim under Section 3 of the Party Walls Act. So strictly, it isn't binding when considering the other sections. Now, that point was one of the reasons why Crowley wasn't followed in the case of Bridgeland and Ellesmead estates. Now, that was a claim for breach of statutory duty under Section 7(1) of the Act, and it was rejected by His Honour Judge Grant, who confusingly was a High Court judge sitting as a County Court judge in the TCC, but it ranks as a County Court judgment. Further, and with respect to the learned judge in Crowley, the analysis in that case is brief, it's entirely inconsistent, and for my view, it's really quite unpersuasive. And this, it's not just me that thinks this is the second reason why His Honour Judge Grant refused to follow it in Bridgeland. So those factors, I think, open the door to arguments being made about the availability of a breach of statutory duty claim, whichever way you want to argue it. Finally, let's have a look at the case of SHAH and Power. Now, this case was atypical. It was back to front because it was unusually the adjoining owner who was trying to avail themselves of the statutory scheme and the building owner that was averring that the case fell under the jurisdiction of the common law and the civil courts. So a very unusual setup. So in SHAH, the building owner carried out works to his semi-detached property, which he maintained throughout did not fall under the Party Walls Act. However, his neighbours disagreed, and when alleged damage was found, they purported to appoint a surveyor in line with the Party Walls Act. Now, that surveyor went on to appoint a third surveyor because the building owner refused to engage, not thinking the statute was relevant, and the two surveyors purported to make an award against the building owner, awarding the adjoining owner compensation for damage and also the costs of obtaining that award. Now, at first instance, a declaration was granted that the purported award was null and void for want of jurisdiction, because no dispute had arisen under the provisions of the Act. This wasn't an Act scenario. This judgment was appealed, but the declaration was upheld by the High Court. And in upholding the declaration, the High Court had to consider two related questions. First, could the Act be invoked retrospectively? And second, could the Act be invoked by the adjoining owner acting unilaterally? The Court answered both of these questions in the negative and gave a number of convincing reasons for doing so. Of particular interest are these three. First, the Court found that the fact that the Party Walls Act could have been invoked in any given situation couldn't justify the Court in treating the case as if it had been invoked. In other words, the Court took the same approach that we have done today in drawing a distinction between facts which make the Party Walls Act prima facie applicable and those which trigger its application in reality. Second, the Court found that the wording of the Act suggested that its provisions were designed to have prospective and not retrospective application. In particular, the Court focused on the definition of building owner that we looked at earlier, the person who is desirous of exercising rights under the Act. Now, it was held that desirous of exercising rights is not consistent with someone who already has purported to exercise those rights. As the Court said, this supports the no notice, no act mantra and the view that the Act does not come into play unless a notice is served. Finally, it was felt that the Court should be cautious before interpreting the Act in such a way as to remove a person's normal right of recourse to the courts. The statutory dispute resolution mechanism was an exception to the usual court oversight and should be interpreted reasonably closely. Without clear words to the effect in the Act itself, the Court felt that they shouldn't allow the unilateral imposition of a statutory regime by the adjoining owner. Now, in my view, these reasons make a great deal of sense and entirely justify the court's decision to uphold the declaration of invalidity. However, they do appear to contradict an obiter comment made by Mr. Justice Eyre regarding Rodriguez. At paragraph 71 of SHAH, Mr. Justice Eyre states that the decision in Rodriguez is authority for the proposition that when a building owner invokes the Act by serving a notice, the dispute resolution mechanism governs all relevant works, including those undertaken before the notice was served. Now, as I've already suggested, for my part, I'm not convinced that that is the only or indeed the best reading of Rodriguez. And the inconsistency in Mr. Eyre's judgment here illustrates the difficulty that that simplistic reading brings. In SHAH itself, on the facts actually before him, Mr. Justice Eyre held to the view that the Party Walls Act is prospective, that it requires triggering by way of originating notice before it can apply, and that it should be interpreted strictly as an exception to the common law and a citizen's recourse to the courts. But the interpretation of Rodriguez that he set out in paragraph 71 goes against those points in all respects, and so for my part shouldn't be adopted uncritically in the same way as Rodriguez should be taken with a pinch of salt as well. Well, that's all from me. I hope that by the end of this talk you feel a bit more familiar with the Party Walls Act, which is not something you may come across every day, and also a bit more alive to the problems that might arise when the Act comes into contact with the civil law. If you have any questions, please feel free to get in touch with me in Chambers, but for now, I hope you have a lovely day.